Get ready for the dictation. Start. The contention of Sri Ramesh Pandey, Learned Counsel for Petitioner, is that having studied in the school for last 13 years and having secured about 89% marks in standard 10, there was no justifiable reason for the school for not granting admission to the petitioner in class 11th. Not taking admission of the petitioner in standard 11 is an act of high-handedness and arbitrariness. The father of the petitioner approached the district magistrate, who ordered an inquiry into the matter, wherein it was found that the principal had acted in a high-handed and arbitrary manner. Therefore, an explanation was called from the school and directions were also issued to admit the student, but the principal of the school had adopted an intransigent attitude and declined to admit the student, citing the minority status of the school and stating that admission to standard 11 was not a matter of automatic promotion and it was the discretion of the principal to admit or deny admission to a student in standard 11, which according to petitioner was arbitrary in nature and hit by Article 14 of the Constitution. The direction of district authorities had also been ignored by the principal. Sri Jaideep Narayan Mathur, learned senior advocate appearing for opposite parties 8 and 9, submitted that the school was a private minority unaided institution. The admissions up to standard 10 were as a matter of right as they were in the nature of promotion from lower standard to the higher standard. As far as the admission to standard 11 was concerned, it was not as a matter of right, as it was not a promotion but was a fresh admission, and fresh admission forms were required to be submitted. While taking a decision regarding admission in standard 11th, the principal of the school undertook a consultative process with the teachers wherein the conduct, behavior and assessment of record of the student as also their guardians were considered. In the case of the petitioner, it was found that the teachers were unwilling, rather adamant not to have to do anything with the father of the student, who had been causing enormous problem not on one or two occasions but regularly. He had problems with the ethos of the college and was not able to come to terms with it. He did not want his ward to participate in extracurricular activities which were necessary for the overall development of the student. Learned Counsel also submitted that it was not the petitioner alone but several students who had passed standard 10th from the institution and had been studying for long who had been denied admission to standard 11th. One of the students had secured 97% marks, yet he was denied admission. Stop.